Welcome to AI and Intellectual Property in Film and Television, Ownership, Rights, and Risk Management across Greece, the UK, and the US. I'm David Shraga, a member of the executive leadership team of the Beverly Hills Bar Association's Entertainment Law section, and I have the privilege of introducing this fantastic program today. Before getting into today's excellent seminar, we'd like to acknowledge the continuing support of our friends at Lawyers Mutual Insurance Company, who is a valued sponsor of the Entertainment Law section and helps enable so much of what we bring to our membership and the community. For 5 decades, Lawyers Mutual Insurance Company has been the only California-based company to continuously provide lawyers throughout the state with professional liability insurance coverage. Their experience and expertise are complemented by the fact that LMIC is directed by a group of dedicated lawyers. They offer special rates with competitive premiums for a wide range of areas of practice, including entertainment law. We know these individuals, and you will find that their team has unique expertise in the entertainment industry and a particular familiarity with the complex issues that entertainment lawyers navigate in their practices. So learn more about them at lawyersmutual.com. We have a great program for you today with a panel of 3 speakers that hail from around the globe and offer a truly international and expert perspective on today's topic. Thanos Leontaris is the managing partner at Ratio Legal Services in Thessaloniki, Greece. He specializes in IP and entertainment law with extensive experience drafting financing and distribution agreements, cash rebate and production contracts, and advising producers and distributors on commercial and regulatory matters. His practice also spans blockchain and commercial technology, and he is duly licensed in Greece and Cyprus. Sarah Kundal is a senior associate at Lee& Thompson LLP in London. Since joining the firm in 2017, she has advised producers and financiers on all aspects of the development, production, financing, and exploitation of scripted and unscripted content, with a particular focus on film and television financing. Michael Peters is an attorney at Ramo Law here in Los Angeles, whose practice focuses on the intersection of media, entertainment, and emerging technologies. He specializes in music rights management, media financing, and dispute resolution, advising artists, content creators, and entrepreneurs on building and protecting their media presence. And now, let's get started.
Thank you, David. Thank you all for joining us. This panel will be more of a conversational kind of sharing of ideas, perspectives, compare and contrast. We welcome questions as they come up. So please put them in the channel and we will look at them as often as we can and respond to them in real time if it's fluent. I'd like to start with hearing from Sarah and Thanos on the kind of state of the nation as far as copyright and intellectual property as it relates to AI. And so I'll start with Sarah.
Great, and a pleasure to be here. So in the UK, it's, I imagine, similar to everywhere in terms of the general consensus is excitement and trepidation. It's trying to find the balance between encouraging technological innovation, but also protecting those rights holders and copyrighted works. This webinar has actually come at quite a good time because the UK government issued some guidance in the last couple of weeks about how the ownership of copyrighted works and also how AI training data can use copyrighted works. Last year, the UK government was floating the idea of having an opt-out mechanism so that automatically copyright holders would need to opt out from having their copyrighted works used to train AI. This decision, that step back from this, which is what the guidance this month has done, has been welcomed by the creative industries, meaning that any AI platform that wishes to use copyrighted works for its training data will need to specifically license it in the usual way. So that has generally been a positive thing for the creative industries. The sort of other main topical thing in the UK at the moment is the ongoing negotiations between PACT, which is our Producers Guild, and Equity, our on-screen performers guild. Negotiations are ongoing in respect of AI. They have different views in that PACT believes that rigid restrictions would impede and hamper a producer's job and making it even more difficult to make content in a time where it's already pretty hard to find financing. And Equity believe, though, that The technology has changed sufficient to warrant revisiting the pact agreement, and specifically in respect to things like digital replicas, which, whilst there was always some level of digital replicas in the last few years in terms of the sort that you see in VFX, etc., the technology has advanced to an extent where it's definitely worth revisiting, and they are pushing for more rigid restrictions to protect their members.
Just so for anyone that's not familiar with UK customs, can you distinguish pact and equity really quickly?
Yeah, so PACT is the Producers Alliance for Cinema and Television. So they are probably one of the most vocal groups in the UK from the creative industries. We do obviously have writers' guilds and things like WGGB, but generally PACT kind of leads the charge in terms of issues that crop up, commercial ones such as AI. And equity is our on-screen performers, so it's actors, stunt performers, etc.
Thank you. Thanos.
Sure, thank you. Look, I mean, my intention is here to also bring the European perspective to this conversation. So I will just get started on some of the legal items here. Obviously, the European Union is, until since last year, one of the first jurisdictions that has its own Artificial Intelligence Act. So we have a uniform legal instrument that regulates a number of things around artificial intelligence, generative AI as well, and content created with the use of AI. Specifically, one of the things that interests us, obviously, is the fact that we will need to have specific banners and making sure that content created with generative AI has to be properly noted as such wherever it is being distributed. Right now, I guess the state of play is that people are realizing more and more in the industry that generative AI is not only text, obviously. Now we can use AI for a number of things in the entertainment industry and creating, like you said, digital replicas, Sarah, and creating twins and creating any number of things in the entertainment space. What we're seeing the past year is that there is a big push by the equivalent of European unions, such as the equivalent of SAG, which is the Euro FIA, to have more regulation within the AI Act in regard to copyright and some of the creations that AI will create, so on and so forth. However, Europe had, since 2021, which is interesting, a copyright directive which was very specific in regard to an opt-out that was machine readable. So essentially, if you have any content online, even let's say in my law firm's website where we post articles, we can put an opt-out on our terms and conditions that would disallow machine learning and AI to read our content and learn from it. So this has existed since 2021.
Wow.
In light of this, yeah, it's very interesting. Of course, this is not very pertinent, I would say, to the entertainment sector in the sense that we are creating moving pictures, but it can be relevant when we're talking about scripts, obviously. So in that regard, depositories that might be machine readable, meaning that that's the term that is being used in the regulation, actually, in the directive, I'm sorry. Depositories that you post your ideas on, your potential scripts or whatever those may be, unless you have an opt-out, it creates this issue. An AI generative tool can use it to learn from it and create new IP from it without you getting anything at all. So another component to the unions, such as EuroFIA, which is the equivalent of SAG for Europe, is the European film agencies and the European Film Academy, which are also taking steps to push the European Union towards a uniform way that we will treat copyright and in the AI era. And of course, making sure that creators' rights and the rights of the performers, obviously, they're being protected. Remember, of course, that we have a very peculiar situation in Europe in the sense that we are not allowed to waive all rights in a similar manner that in the UK and the US, you're able to waive most rights, I guess, based on my understanding in copyright law. That doesn't exist technically in Europe. We have the droit moral, which is really important for European creators, and you essentially you're licensing everything. Nothing is actually being transferred legally speaking. So for us, that also shapes how we're going to treat AI creations and how we're going to treat the uses of AI in performances. The one thing that I've seen, which is interesting to me, just that in terms of monetization, and I think this probably has come up for you guys as well, is the fact that a lot of libraries are now being given from producers to AI training tools, and they're creating a new revenue stream for them. And that's really interesting for me
Hmm.
because in Europe, because we have this issue with licensing, essentially you have to license everything. There's no technically you can't do a catch-all. So you have to be proper in terms of how you license everything. So unless we have properly licensed the material for training of AI, I'm in the gray. I mean, I'm not feeling comfortable providing the advice that you're okay to give it out for training and we can then use it to monetize. So this will create an interesting issue, and it has already created this issue, I guess, in terms of whether we're able to actually give this material for training
Mm.
or not because the industry being what it is right now, I mean, you want to create new revenue streams for your clients, and you want to be able to help them monetize some very old libraries that they have. It's not like that they're doing anything with it anyway. So I
Yeah.
guess I think that's also really interesting. And of course, and I guess I'm sure that's something that has come up for you guys as well, is making sure that you're able to fix performances, making sure that you're able to use AI when necessary to, create some intimacy scenes as well, which has also been an issue
Mm.
in Greece specifically. I guess yes, that's kind of the state of play where we are right now.
The states, it's interesting that you both that both the territories have kind of played with the opt-out thing, but neither of you have mentioned fair use or something similar to that. Because the state of the law in the US, a lot of it seems to be centered around training and whether what types of training are fair use or not. Um, and we've had some. I mean, case law can kind of be seen as anecdotal in some ways because it's like until there's a wealth of case law that covers a very variety of different situations, you kind of have like in this specific situation, this was the law, and then that can be analogized to other things. So we have things like in one instance, it was found that bought copies of books were fair use for training, but pirated copies of books were not fair use of training, things like that. And so we're kind of patching together this kind of philosophical approach of what is and is not. But even in certain instances, the judge just, really called out defense counsel for not raising an argument that judge feel may have prevailed, but the argument wasn't raised, so the judge's hands were tied. Um,
Is that
I'm
true?
speaking,
Did that actually
yeah.
happen?
I'm trying to avoid specifics because there are other panels that can speak better to this and with more specificity, so I'm kind of keeping it general. But that was my understanding of where it left off. And of course, with any judge's decision, there's going to be a lot more nuance and detail to it. But that's kind of where we're sitting of, um, you know, it's looked at how it's copied. There's, categories of fair use. And I kind of was curious, is there any similarity of or similar concept in UK or Europe as far as fair use of copyright? And has that been part of the conversation as far as training LLMs or any
Hasn't
kind
in
of
the
generative AI?
UK, it hasn't really been part of the conversation. A couple of potential solutions to the in absence of this opt-out provision are just looking at licensing requirements and credit requirements as well, like can content be used as long as it's sufficiently credited.
Hmm.
The one thing the UK is desperately in need of is the case law, because there really hasn't been any so far. I mean, we can say how we can interpret statute, the relevant one being in the UK, the Copyright Designs and Patent Act from 1988, which until Thanos was talking about how there are AI statutes, I thought was actually pretty ahead of its time in that it anticipated computer generated works. Sorry, excuse me.
Yeah,
So we do actually have a provision in the Copyright Designs and Patents Act which anticipates computer generated works. It needs to have human involvement. But as far as the human needs to make the arrangements necessary for the creation of that work that computer generates. But that can be anything. I mean, AI wasn't a thing at the time in 1988, which is when the statute dates back to, and it's now you look at it with a new lens, and it's whether or not that means the human putting the prompts into AI software. Is it the person who designed the AI software? It's just so up in the air. So
Interesting.
yeah.
The other big thing, kind of the more immediate response in our laws and customs, I guess, was the guild strikes. Lar A lot of them were a long time coming. AI was not the only aspect of them, but it kind of accelerated the conversations a bit, more than a bit, especially on the SAG and WGA side. SAG being Screen Actors Guild and WGA being Writers Guild. Um, and largely focused on safety of labor, or like securing of jobs. And that's largely how those strikes got resolved. There was a bit of like nothing was resolved with any specificity, or not a lot of specificity at least, but they kind of found themselves in the lane of, you can't, there's a few rules we established that you can't replace writer jobs. So if one writer works on a WGA project and the rest is written by generative AI, that one writer that worked on it is basically deemed the writer of the whole thing. Things like that. And then SAG did a lot of work with the California legislature to do and that's actually now a law, that relates to digital replicas. And now we have, I can get into a little bit later. We have a law in California that has a number of requirements that if they're not met, then the contract is unenforceable, at least with regard to the use of digital replicas and generative AI. And then SAG, that was kind of mirrored the SAG um, contract as it relates to that. The SAG one being a little bit more inclusive, and the state law being a little more one of the one of them has to be met versus all of them in the SAG deal.
It's
Um,
interesting you mentioned the strikes actually, because that is something that could potentially happen in the UK with equity. Um, in December, I believe it was, I think 99% of equity members indicated that they'd be open to some form of industrial action, which is quite a big percentage. So it's clearly at the forefront of a lot of members' minds. There was an open letter as well with about 1,500 signatures of really prominent British talent, all championing more rigid requirements. Whether or not that is going to result in full industrial action and actors refusing to turn up to set, or whether it's going to be something more small scale, i.e., refusing just to do body scans if required. That remains to be seen, but that is unfortunately at the moment it does feel like that could be a possibility if equity and pact can't meet somewhere in the middle.
I think that just going back a little bit to the fair use point that you were making before.
all right.
We do have a very small carve out for fair use, but it's not for AI. It's only for educational purposes and non-commercial purposes. So for us, fair use is it's not really something that you can use to license stuff for AI. I think that in regard to what you were saying now, Sarah, I think that wasn't Elton John one of the people who was part of that? I mean, I remember
So yeah,
listening to his interview on that. I mean, it was. I think that at least on our end in Europe, I think that the one way that people will be pushed to make changes, I don't know if they're going to be good, bad, or whatever those may be, but I think that the agencies who are financing um, the film production industry in Europe will take a bigger part in formulating some of this policy because, like BFI in the UK, and for us, ECOME, the Greek rebate agency, or the Center for Cinema in France, and the equivalent in Germany, they hold a lot of sway in terms of, how policy is determined and how the legislation evolves. And I think that if you, for example, like take out of eligible spend stuff that has to do with AI, I think that everybody will get the message that, some stuff you can't do with AI or with AI tools. So if we're not going to finance you for it, you should probably be doing it, even if the law, it delays to do something like this. Especially, I think that if the French, unions of actors, producers, and if they are taking some initiative, I think that in a similar manner that the Germans had actually last year produced a report on it, the equivalent German Union of Actors. I think that Europe will be pushed to create some legislation because for us in Europe, film agencies, because we're very much reliant on rebates, be it tax credit or cash rebates, they hold a lot of sway in terms of how the industry will progress in that regard.
And with the Greek rebate, Panos, are AI costs, would they typically be qualifying expenditure?
See, that's a good question. It doesn't say it's not. So if you were doing it in post, I think that I would call it a post-production expense. So in my opinion, it should be, yes.
Yeah,
Unless, otherwise, noted as such. Yeah.
yeah, it's similar in the UK. I mean, most of the instances would be in post anyway, and there's not been any
Yeah.
guidance issued as to that being excluded. It would qualify for our tax credit.
Yeah. Yeah, and I mean, yeah, I guess that's why we're different with the US so much, right? I mean, the US, I don't think that you care so much about rebates internally in the US, right? I mean, except I don't know,
Oh, we
Georgia,
do. The independent film market is
okay,
heavily where someone's shooting is heavily reliant or dependent on the tax credit a lot of the times. But I don't think I kind of agree. I think it would kind of pan out the same way unless someone actually decided to take a stance. And it would be like a state level tax credit. We would kind of have a federal tax credit that kind of comes in and out, called the 181 section. There's like it's more of a tax break than a tax credit, but um, I think that's going to be something that people will just have to like decide to make a deal out of because it largely is a post cost.
Yeah.
Although I have seen, we can talk a little more about implementation and creative or cultural responses and applications later. But there's been some interesting case studies of like real-time visualizations on set. So instead of a green screen, you can kind of see like what it's actually going to look like while you're filming, which is I think is very exciting. But we're close to the halfway mark already, so let's keep this going through our topics. We've touched on authorship a bit. Also, side note, we could do a whole other panel just comparing creative like community cultural exchange concepts with or without fair use as a commercial as a with a like commercial possibly commercial applicability of fair use because commercial application is kind of one of our standards, but it's interesting that neither has it really because it's a very fundamental concept for us in a lot of ways. Like most independent films have a fair use opinion on materials used, especially documentaries. But let's talk quickly on authorship. How are you guys defining authorship versus when Gen AI is involved?
I think I probably already covered the UK stance on this, so maybe Thanos, if you want to talk about Europe. In summary, it's a human author, but in terms of computer generated, it's who that human author is. It's really unclear until there's some case law.
Yeah.
I would say the same in Europe, but let me ask this because we're all attorneys here, and I just want to have this discussion with someone. So look, let's say that you use ChatGPT professionally, like you have an actual subscription and a proper data processing agreement that we have to have in Europe and terms and conditions and so on and so forth. You pay for it properly and all is well. I'm wondering, since you have a service agreement with that tool, isn't it defined in the terms and conditions what's the IP?
Kind of. And this is a great question. This is exactly what I wanted to talk
You know what I mean? Like
about.
we have
Um,
a service agreement with them.
so particularly Suno, I've read their terms of service multiple times now and from multiple different angles
Why?
of problems to solve.
Why?
Either,
Why are you reading terms and
e-
conditions? You're a lawyer. You're not supposed to be doing that.
because either a client makes
We
something with
take them
Suno
on
and says,
trust.
what rights do I have here? Or a client is receiving rights
Right,
from
right, right.
someone that used Suno. And then I kind of have to, look at, okay, it's a kind of a contract, right? So there's a contractual right of, is one party going to be a problem for the other for exploiting this? And then there's the concept of authorship, which is a much more intangible but much more meaningful concept in copyright is like you are the author. As I understand, like in a lot of European territories, like the authorship and joint morale like are heavily entwined. We
I
have
agree, but
some kind
Mhm.
of thing like that where we have a termination right for an author if they will assign their copyright, they can take it back years later. It was kind of our response to the renewals being alienable, and so this is not. But the problem in my mind is kind of shifted to is it protectable? Not do you have the rights to use it? Because if it was just prompt to output, right now copyright law says no one owns that. That is just it is immediately public domain because there is no human author. Until our law changes, I think that's how it sits.
Yeah, so with prompts in the UK, they are technically copyrightable. It would qualify as a literary work, which
I agree.
depending what the prompt is.
I agree.
Um, but the thing, in order to, again, I don't think this has ever been through the courts, but technically that's what the statute is. I would say that you'd have more likelihood of it if you wanted to test it, of it qualifying as a copyrightable work, a literary work, would be to in the prompt would be talk about creative character development and set out something that's really hate to repeat myself again, but creative. Yeah, character stories, a setting like a world in which this. If you wanted to get AI to write a forest based fantasy or something, if you go to great detail and set out the sort of prompts that you want it to take into account, then it's more likely to be a copyrightable work because it in
Yeah.
itself is a literary piece.
So my understanding and how I'm kind of approaching the problem is that, you know, the Copyright Office will look at, okay, tell us the human intervention. Tell us what humans did, tell us what a robot did. And then they'll protect what a human did. So if you have like a sketch, like a kind of a crude sketch, then the AI then makes into like a polished looking album cover or something, they will protect the crude sketch, or will protect the elements of the crude sketch that show up in the final product. So to your point, Sarah, if and I think there's a common misconception that a lot of generative AI use on the professional level is just prompt to final product. And it's really a nauseating web of different generative AI platforms,
Yeah.
different workflows, LoRa's, and all these other things, often custom built LoRa's and things like that. So there is actually, even if it's just heavily, every output was made completely by generative AI, there's a lot of human direction in all of it. And so the guidance I'm leaning towards is, documenting everything. And I have some
Yeah.
clients that actually implement software, or I don't know if they've actually finished it yet, but they've been working on software that will track everything that their people are doing in their workstations so that they actually have a record of everything a human did. So when it comes to protecting the output, they actually have as much data as possible to show that this was not just, write me a forest story about some elves. It's like, they actually the humans to dictate the characters, the humans dictate the pacing, the humans dictate the plot points. It's just generative AI is kind of filling out a structure.
Yeah, for
But I
sure.
feel like our laws need to kind of catch up
Um,
to that.
I think that it's different when you ask ChatGPT to write you a joke about a Greek, a US, and a UK attorney participating at the BHBA. And it's different to, like Sarah said, to give it so much prompt that it just again, like you said, like polishes something. And we have a default in our copyright law that says that by default, salaried employees, any creation that they make during their work, by default goes to the employer. So whatever, be it
Mm.
software, literally works, whatever that may be, so long as it's part of their work, because they're salaried employees and not work for hire, by default, all rights go to the employer. To that regard, what I'm trying to say is essentially what the legislator has recognized here is the fact that this employee probably is getting input from someone to create, right? So while it is a human being creating, it is obviously getting input and guidance from someone else. And that's why, in my opinion, the copyright law in Greece, and I think it's the same in France and Germany, because we basically have the same copyright laws. It's because it's being recognized that the employee is acting under someone's supervision and guidance to create. In a similar manner, if you're giving guidance, supervision to an AI tool, I don't see a reason why the authorship couldn't go by default to the person essentially licensing it. You know what I mean? Like,
I'm inclined to agree.
that's what
And
I
just
think.
just for
Okay.
context, the case law that we're working with in the US is a monkey or a gorilla or some kind of primate that got its hands on a camera that
Okay.
then pressed the button to open the shutter, and then that photo was taken. I think it was like kind of like a selfie of a monkey or something like that. And then there was a copyright issue of the camera, the person that owned the camera said like I set up the camera, like I dialed in the settings. It's my camera. The monkey just took it and took the picture, and the court was like, no, that's the a non-human took the picture, so there's no copyright granted to that picture, and that's what's being applied to generative AI.
I've been, you and I both teach at universities. So like, w one of the things that I was teaching at the University of Nicosia, and we were talking about it for smart contracts and blockchain,
Hmm.
was that some of these technological issues we're dealing with right now, the legal issues around them, will take us down to the fundamentals of law. And it will either require reinterpretation of what we're doing on existing legislation, whatever it is that we're doing now, we'll have to go to the fundamentals of the monkey, like you correctly point out, or we're going to create something completely new to accommodate all of this. And I think this will be really interesting what approaches each jurisdiction will take. Europe is overregulated, so we know what we're doing. We're creating new things all the time for whatever reason. But hopefully we'll get some case law soon enough to give us some more guidance on how to do some of these things. Yeah.
I
But
have another thought.
sorry, let me go
Hmm.
back to what you were saying before. You mentioned the Copyright Office in the US. Now, me and you, we actually had this discussion before, and Sarah separately for another project that we did together. You both have copyright offices. I mean, in Europe, we don't really use them, to be completely honest with you. The registration of copyright, I know it's not necessary for legal purposes for you guys as well, but it obviously it helps. As you explained to me back in November, it helps you for I guess to be able to sue someone. You
For
told me
damages, for
for
standing and
damages,
damage.
right?
Yeah, so
Can you
in
please,
a
yeah,
lot of ways, it
elaborate on
is
this
very
because I don't understand.
necessary.
Yeah.
I think it was 2019. There was a split between the West Coast and East Coast, ninth and second, I believe, circuits as to whether you needed a valid registration to get damages for copyright infringement. And that's now been solidified across the nation. You do need a valid registration. And that's why it's really consequential what the Copyright Office says about these, um, like registering a work that has generative AI included, or that has a contributions from generative AI, because if you're going to put a commercial project out, you want to be able to protect it. And if it's someone's going to infringe on your market space or just steal your work, you want to be able to enforce that. And enforcement is very expensive, and having a healthy up to six-figure punitive damages or statutory damages is a really meaningful thing for being able to actually enforce your copyright. DMCA is helpful in a lot of ways. But sometimes someone made a bunch of money off of your stuff and you want to you have people to answer to for that. So I would say it's very necessary for us.
No,
Even
I'm
though
I'm
in abstract it is protected, you can always prove it's yours. with the right
Right.
evidence. But yeah.
No, but I'm just asking, this doesn't really sound like just registration because we do have a copyright office in Greece, for example, and in
Mhm.
France and in Germany and so on and so forth. But they only act as record keepers, so to speak. They don't go into the substance. But what you're saying is that in the US, it goes into the substance of whether this is actually copyrightable content. Okay. Is it the
Yeah.
same in the UK?
No, and this is kind of more from a chain of title perspective, but a CP or a conditions precedent
Right.
to a lot of financing in the UK would be evidence that the screenplay had, of a film or TV or script from a TV show had been registered with the US Copyright Office.
Mm.
We care more about that. Um,
The reason why I'm
I,
asking is because when we're talking about it for the UK, for the one of the projects we did together for your CPs, you told me you were asking for the US and not for the UK, which
yeah,
was interesting to me as well.
yeah, I've run into that too.
yeah. So
I've sorry, go.
I was just going to say, I think that security works a little bit differently in the US as well. Michael, is that right? So you can the copyright mortgage, for example, is registered separately, whereas and it can be you more it's more securities assigned to the actual work rather than the owner. Whereas in the UK, we can only really take registered security over a company, so it's the owner of that asset as well. So I think that's why there's a bit of a
Yeah,
differentiation.
it's a state versus federal distinction, and federal will supersede. So that's why federal is copyright. So we take a copyright mortgage and file that with the Copyright Office, and we take a UCC, which is state level, over all the, UCC level, properties like, chattel, equipment, banknotes, and things like that, accounts receivable, et cetera. But we have to do both in the states because there's a likelihood that if challenged without the copyright mortgage, you may have copyright law supersede the UCC state level lien. So that's a little bit of a tangent into film
Sorry,
production stuff. And no, it's good. It's fun. It's a fun.
interesting for me.
I
No,
find it interesting too. I just spend a lot
but
of time in this space.
it's a very critical thing because look at this. Like you mentioned, Copyright Office in the US says it goes into substance, whereas in the UK it doesn't go into substance. So if you want to, if you're not sure about your AI stuff, you will go to the UK just to be on the safe side that at least you have something registered somewhere. So at least
Yeah,
that's something.
I kind of look at them as their own independent body. They're not a court, they're not legislation, but people do look to them for guidance. And every time I file a new work that has some generative AI element to it. Sometimes though the explanation is, sufficient for whoever's looking at it. Sometimes it's not, and they'll email me and say, "Hey, can you get more information as to how Gen AI was used versus human authorship?" So they are actually looking at it. A lot of copyrights they won't unless they find it like a objective problem, and then it's just kind of that's the record you put into the system, and that's what's challenged when you sue on it. Because back to the point of, you need a valid registration to sue for damages. The first thing the defendant does in a copyright suit is attack the registration to try to invalidate it. Or one of the first things. Yeah.
It was
So
So
interesting.
it's
copyright protection in
Sorry.
oh,
hmm?
No,
I
no,
was
go
going to
ahead,
say
sir.
copyright protection in the UK is automatic, so we don't need to register it. And so if we do, the reason we care more about the US is, I mean, generally because that tends to be the biggest distribution deal as well. It's chain of title, distributor's going to want to check it.
For us, it was interesting the fact that it was one of the things that the EU film agencies, super union, let's call it, one of the recommendations they were making to the European Parliament was to have the EU IPO, which is the European Intellectual Property Office, where we register trademarks and designs throughout the EU, to have a role in this sort of thing for copyright now and AI. And it's possible that in the coming years, if that proposal actually does go through, that the EU IPO, which already exists, since the 1980s, will actually get a role in registering copyright to that effect as well. So that was interesting for us too. It hasn't happened yet, but it's the fact that we could go there probably takes a cue from the US on that.
Hmm. So we touched on inputs and outputs, and I think the current guidance is that, an input is not, a prompt is not necessarily, is not in and of itself copyrightable, but we're all operating on, fixed original expression as the key magical keywords for copyrightability. And maybe if you just put a prompt in and you don't actually save it anywhere, is it fixed or not? That's a more of a philosophical question. But I think if it's rises to a level of original expression, I think I'm kind of expecting in the future some decisions to come down that would grant protectability for a prompt. But the problem is that if any of you use image or video generators with AI, uh, there's a lot of different things that a generative AI platform can do with a singular prompt, even a detailed prompt. And then that kind of raises the more philosophical copyright question of even a detailed prompt, if it can make a variety of very different images or videos, would that be, is that actually expression at that point? Or are you just protecting the prompt? And if someone wants to use the prompt for whatever they want to use, but the actual generations are not actual human expression, they're just, the hallucinations of a machine based on actual human expression. That's kind of what I'm struggling with right now as far as the prompt versus output protections and stuff like that. Because I think it's going to be dangerous to say, okay, anything that this prompt creates can be protected. What do you think?
It sounds difficult. Sarah should answer first.
I was really hoping with Darren. No, I completely agree. But again, we just don't have any guidance on this in the UK.
Yeah,
It's just
it's going to be, yeah, I mean, it's kind of a wait and see thing. Um,
yeah.
it's going to be interesting to see how it figures out. Um, how's the cultural response? I mean, there's a lot of doomerism in the United States. But I feel like it's kind of shifting as people kind of figure out like, Y2K or the internet or, everything else that's happened before. Everyone kind of like goes the worst case scenario with the new technology. I do think that this is scarier than most technologies that humans have ever created. It's also just more uncertain, like of what it can do or what it will do. But, how's the temperature over there?
Yeah, I think it's again sort of excitement mixed with trepidation, but it and certain types of AI that we're seeing, especially in film and TV, so it's kind of more limited to film and TV than AI in general, is it's exciting. Like dubbing, for example, like being able to sort of almost AI a foreign speaker onto the body of an English speaker, a well-known actor, is really exciting, and a lot of people are hoping to be able to have a play with all these new tools, but that also does come with the law needs to catch up with how quick that this technology is advancing because it's just not over here. It's lagging behind, and I think with the uncertainty, it's what makes people quite nervous.
Mhm.
I think that there hasn't been how can I say this? We don't have such a huge industry in Europe right now to have, such big issues in terms of like how we're utilizing most of these AI tools, but only because I don't think that people and the creators specifically have realized how producers can monetize what they already have from them um, to use AI tools. Like, for example, like I said before, being able to monetize entire libraries, um, without any compensation to any creator or uh, creative participant is an issue. I mean, we do have two clients right now that had very good offers to buy out libraries for AI training.
Hmm.
And the advice from us was, not only was it a legal risk because we're in the gray for sure, um, but it was also a reputational risk because
Hmm.
if you're in the gray and say you take a chance and you say, you know what, we're going to take the chance, we're going to give you the advice that, we believe that based on X, Y, and Z contracts that you have, that you can give over this library and have them train off of, everyone's performance and so on and so forth. you are jeopardizing your relationships with the creators because, if they figure out that you're doing this, you're not compensating them, they will never trust you with your projects again. And especially if our clients are doing high quality stuff that you're relying on good creators and good performers to be in them, you're not going to get them again. It's a relationship type of world, where we provide our services. People know each other. They want to be able to trust each other. And their creativity is what makes them money. Similarly to how we, make our money by creating and drafting contracts and doing, intellectual work. So again, it's a legal issue as much as it becomes a reputational risk if this is not resolved in terms of if we're able to use AI in some of these instances.
Yeah, it's kind of a know your client kind of thing. It's I mean, I know some areas of the industry are kind of clamoring to, get what they can now, as far as, seeing AI as a major market threat. And so they're kind of welcoming these licensing opportunities because it can, it's kind of might as well get something out of it because they see the writing on the wall that like a lot of the kind of faster licensing models for content are going to be likely replaced. Not necessarily, but it's, I think it's kind of an inevitability that, you know, if people can just create custom stuff very cheaply that's duty free, um, the more bulk licensing content is not going to be as lucrative as it was before. As far as there's also this interesting concept that I've talked to some people about, attribution and like using AI to analyze generative AI material to attribute to existing people. And if that something like that works, then you can kind of have a continuing revenue stream related to training AI and licensing it for training AI, because then there's a way of it coming back to you. But that's to be seen whether or not something like that will ever be embraced. I mean, I think it'd be a good thing if it did,
But but
but it's kind of a buyout right now. If you license for training, then you're not. I don't really see a direct way of guaranteeing you're ever going to get any more money from that, unless except maybe there's like it's a multitude of LLMs or digital brains that can be trained, and each one of those is a new license. But eventually, we've seen everything consolidates over time.
I think that the only way that you can do something like this, if the AI tools that are being used in our industry are required, contractually or otherwise, to give us a list of the works that they used. That's the only way.
Yeah,
I mean that's the only way is provenance, making sure that we know where it's coming from.
that'd be a
Um,
hell of a list, though.
I mean,
It's gonna be
it will
massive.
be sure, but at the same time, like, you have residuals being paid to actors, to writers, so on and so forth. You have, all these rights that we're paying to creators. Um, they're also huge lists, when we have
Hmm.
to pay residuals, for example, of course, but huge or otherwise, we have to know what was being used. And of course, you're writing something on Claude or on ChatGPT or Copilot, and it gives you all its reasoning behind it. Why can it not give you the references it used and cite what sources it used? I don't see a problem with that. It's supposed to be
In
smart, so
concept,
it should be able to do that.
yeah. The reality is that might be so bulky that only an AI could actually utilize it.
Listen, let me ask you another question. I mean, you also do music, if I'm not mistaken, right?
Hmm.
I mean, you take it on trust that, Apple Music actually pays what it's supposed to pay, right?
Well, after we could also do another panel on this, but a few years ago we had the MMA, the Music Modernization Act, which basically precluded a bunch of pending lawsuits
Mm.
in favor of a blanket license. And I'm pre if I had to predict something that related to all the training lawsuits in the U.S., I think something like that would be a solution.
Right.
And I wouldn't be surprised if they kind of defaulted to that because we had a similar situation. Just everyone was suing Spotify and Apple and everyone else because it was too much to license to, kind of their credit. But also, like, I don't think they were that motivated too if they were getting away with it. So then you just had like, okay, everyone's doing the same deal. Here's the blanket license. Mechanicals get paid to the MLC, and the lawsuits are gone. Um, and that, I mean, people will gripe about anything and people have valid gripes about it, but to a large extent, it did work. So we could do something similar.
Yeah, see, that's what I'm getting at though. We were basing it off trust that this would happen.
Yeah.
So I don't see a reason why we can't do it again.
But I
I mean,
mean,
it
that
seemed to
would
have
put,
worked.
by analogy, that would kind of put War and Peace in the same valuation as, a random, local magazine. And so having some kind of attribution or analysis on the back end of like what was utilized in the product might be more fair, but that just adds an entire new dimension of work and complication. And maybe the society would be satisfied with just like, okay, everyone that every piece of work that got used by this LLM can get a fraction of the economic
Yeah.
upside of whatever anything that LLM creates. And they basically just make like a Spotify type royalty pool of this chunk of your income goes to pay out all of these people in perpetuity. It's possible, but it's like it would be. I feel like it'd be more symbolically satisfactory than economically.
I mean, we're creating all these tools. I mean, the somebody has to find a way to utilize them to make them work for everyone. You
Yeah,
know what I mean? Like at some point, it's
I
like
I agree with you
I get
completely
it.
there.
I mean, I get it. You're right. It's complicated, but they
Yeah,
need to figure this out. If they're taking advantage of everyone's work,
right. I mean,
it's only fair.
there's also a possibility that the United States courts will lean towards, as long as you had a valid copy, then it's a transformative use and it's fair use, and we'll see.
Wow.
You'd never know. It's
To
the
me,
courts are
no
always
offense,
in
but
a
to me,
position to be.
that sounds crazy. I mean, honestly, the fact that I don't have a book right now. I bought a book to hold and read, to love and to cherish, and to for it to to essentially be a license to train AI. I mean,
Yeah.
it doesn't make sense. I
A
don't know.
bit of a devil's advocate there is I don't see it being that much different than how a human brain interprets and stores and transforms the wealth of material it's
All,
ever read. But then we're
only in terms
talking,
of speed and
yeah,
and
volume.
volume. Yeah, magnitude. I was going to say, but yeah,
Yeah.
volume too.
Before
Scope.
we're done, I did want to, because we have a kind of right of privacy issue in the United States that's being pushed through legislation as a federal right of privacy, which is new for us, very much sparked by AI and the capabilities, rather nefarious capabilities of AI to create deepfakes, to create fake political ads, to create very convincing knockoffs of artists' work and things like that. And currently, we have everything state level, and we're pushing through a federal. Well, hopefully, soon we'll have a federal right of publicity or privacy or general name and likeness rights. Um, if I was to guess, I'd say Europe was ahead of us on that, but I'm not sure. So do you know where you guys stand on is that a thing? Is deepfakes a cultural hot button
Well,
right now for you guys?
actually, it's weird. We did write an article on our website 2 or 3 weeks ago for deepfake nudes, and some what you can do criminally and civilly to litigate. It is becoming a huge problem, weirdly, for underage persons.
Hmm.
It is such a huge issue. And there have been a lot of criminal cases in litigation. Um, and of course, it has to do with personal data as well and the right to privacy, but it's not what you would call the right to publicity or the right to likeness, like you guys have that right, I guess, in the US where you can, license it out and so on and so forth. It's not that per se, but we mostly tie it to personal data, to be honest. Yeah.
Hmm.
We see it
Yeah,
as a
data.
personal data violation. Yeah.
Yeah, it's similar in the UK in that, again, this is kind of verging out of my media bubble, but it's more online safety. And as Thanos says, like sexual deepfakes are really the thing that statutes
Mm.
trying to protect against at the moment, rather than sort of the non, you know, funny memes that don't have a sort of dark side. But similarly to Thanos, in terms of data protection, the UK's got quite stringent rules, not quite as strict as the EU, I understand, but that's one of the main concerns with AI and things like body scanning and stuff like that. Special category data under UK law, there are data protection regs. They need to be processed in a particular way. There needs to be encryption, and it needs to be absolutely necessary. So it's contractual necessity. So you couldn't just say, can we do this whole body scan of someone who appears in the background of a scene, an extra, just in case we need to use it in the future? Like it's not contractually necessary for that in order to create the original film and stuff. So it's a real minefield, especially in the UK with data protection and that special category data, which would include things like voice recordings and stuff. It's really heavily protected.
For us, it's all about proportionality, actually. I guess it's the same thing to what Sarah is saying, basically. If it's not absolutely necessary for the services to be provided, you can't, you know, have a blanket license to do something like this. Yeah, it's basically how it is here too.
Okay. That's I mean it's not dissimilar to the SAG rules or the California law on digital
But
replicas.
California has its own privacy law, right? The
California does.
CPCA,
Most
right?
states do. Like all states kind of have a different like right of publicity, right of privacy. But the problem is like Dina Lapolto so eloquently illustrated the last time I saw her in a panel is like one of her clients there was a video of or a song that came out with like a collaboration, fake collaboration between one of her clients and another huge celebrity. And it took like a week and like a village of all the interested parties to come together to find some way of getting it down. Whereas like
Wow.
if it's so obviously designed to be a fake of a celebrity or a very famous singer, one would hope that there would be a more direct way. And I think eventually it got taken down just by relationships. It wasn't like an actual mechanical legal mechanism that redundant, but there was an actual legal mechanism that took it down. It was the label and Spotify had a relationship, so they're like, okay, we'll take it down.
Yeah, again, slightly out of my wheelhouse, but we have the Online Safety Act in the UK, which would probably be used in that case, and also Ofcom, which is our broadcast regulator that also can regulate certain social media stuff as well. That they would be the people probably in the UK that would do that and be able to get content taken down.
No,
All right,
we
we got
actually have that covered in our Digital Services Act.
hmm,
Now there is a proper legal a regulation which is uniform throughout the EU that regulates all platforms like YouTube, Facebook, Instagram, so on and so forth in terms of how they put out content, and they have to have a proper a good process in terms of how we can request takedowns. They have to have a proper person that we have to serve with legal documents to take stuff down. Yeah,
hmm.
we do have that since a year and a half ago, or something like that. Yeah, we haven't had to use it just yet, but there is a process on how you do that.
Interesting. Well, we're just about out of time. Do either of you guys have any closing thoughts or statements? I think I've been checking the channel. I don't think we have any questions from the audience. So,
We
we have
we have a
some questions
few.
from the audience. Yeah, yeah.
oh, then I don't see it on my phone. So, like, if one of you can lead that.
Sure, I need
Uh,
to drop off imminently, but there's probably only one for me in terms of the UK. I know two. Okay, so if the script is registered in the US, for the UK, then is that just evidence? Does the UK registration achieve the same goal in UK courts as it does in the US? Meaning, does that get to you? Does that get you the same damages? So yeah, there isn't a you don't have to register the copyright in the UK. And I think this was probably answered after this question actually, so apologies for repeating. But so the reason why most in the UK world we'd ask for US copyright is more just a complete chain of title thing, and obviously like the US deal is probably going to be one of the most valuable, and US distributors are more likely to check chain of title, etc. So that's kind of why we want to see that, and because it is the only sort of registration available. Then what else do we have? Michael, one for you is with regard to US copyright law, has there been any discussion about the risks of prompts being considered collections of unprotectable ideas rather than protectable expressions?
Unprotectable ideas. I mean, I would see a prompt just as any other work, which, everything's derivative. If you literally take someone else's work and put it into a prompt, I could see a very good argument for copyright infringement there. If you were telling an AI to replicate something copyrightable, like a character, a well-known Star Wars character or Disney character or something, then you are basically intentionally making the generative AI infringe on someone else's copyright. Um, I think that answers the question as I understood it, but I may not be understanding the question. Does that sound right? Can you read it again?
Yeah, sure. Actually, it seems to have disappeared. So I'm imagining
Okay.
you have answered
I
it.
guess that I'll take that as answered.
We answered it. It was
Uh,
great.
One for you, Thanos. In the US, for performers, one of the protections for outputs used is a right of publicity, which is a protection of the ability to monetize one's image. Those laws are state by state. Are there equivalent laws in the EU?
Well, we don't have equivalent laws in the EU uniformly, but in continental law, we would probably call it the right to personality. So essentially, it's kind of the right of publicity, but we call it the right of personality. So it's kind of the same thing.
Okay. Is only the prompt the literary work in the UK and EU, or is the output based on a detailed prompt also protectable? Kind of depends what the output is, to be honest, in the UK. Yes, probably. But again, kind of depends on the human involvement in creating that prompt. And Thanos, I think pretty sure
I
that's the
think that the
situation for
over
you as
under
well.
on giving a response that included it depends by
Yeah,
lawyers is it's
but it does.
off
No,
the charts.
Yeah. It
yeah,
always.
No, but it does depend, obviously, yes. I mean, I agree. I mean, at the same time, I think I don't know how much prompts can be, unless it's something like Michael said, where you've given a prompt that is so long and it includes very detailed instructions and so on and so forth to be protected. But again, like I said in my previous point, I think you always have to take a look at what is the license agreement that you have with that tool. I think that's what's really, really important. We keep forgetting that we have a license agreement with the other party utilizing the AI tool. We keep going to the defaults of the law, but we're not seeing what we've actually agreed with them. I think that's really
Yeah.
important too.
I mean, the other side of that is, the license dictates the rights to whatever exists. The law dictates what exists
Uh,
as far as
You're
a
right,
right,
of
you
course.
know? And so it sounds like in the United States, I'm balancing that a little bit more than you have to, because in the EU, so much of it's just licensing based anyway. But,
Yeah.
talking about, are there any moral rights, with regard to something created by generative AI or that generative AI touched? Because sometimes the prompt is an entire draft. Sometimes the screenplay is the entire draft, and the prompt is just, you know, polish this or give me some ideas of how to restructure this or how to streamline it. In which case, absolutely, the prompt is original expression. You know,
Yeah.
unless they just copied it. But if it's a genuine original prompt, a genuine original screenplay, then yeah, then just because it got put into AI as a prompt doesn't change the character of what it was or what it is.
I only have one more minute, but there is one here that's actually really interesting. Are there any regulations anywhere that require disclosure that an image is AI generated so that the viewer can see it? In the UK, not so much regulations, but that is one thing that the government's potentially reviewing as part of the report I mentioned earlier. But that is one thing that we're increasingly seeing errors and emissions insurers asking for as a condition to granting E&O insurance is disclosure of what AI tools have been used and how. And if content's generated, then have they been separately cleared and gone through neg checks, etc. So it's kind of not answering the question in terms of regulations, but it's definitely something that's at the forefront of film and TV, I think.
We do have
Us.
that regulation in the EU, actually.
Nice.
We do have that. Yeah, it's the AI Act requires you to flag AI generated content. So if you visit Europe and you're using Instagram, there has to be a tag that something is AI created. Of course, it's voluntary. I mean, there's no automatic AI tagging, but you are
Mhm.
legally required to do so. Yes.
I think there is something similar to that in the UK in terms of social media with the Advertising Standards Agency. But slightly again out of my wheelhouse, but film and TV, I
No,
don't
but
believe.
it's a very interesting question because look, technically speaking, YouTube is kind of a social media space in terms of video content. So if you're
Mm,
posting content on YouTube, at least under the Digital Services Act and the AI Act in Europe, you would probably have to disclose the use of AI on some level.
yeah.
So I think that's interesting to point out.
Yeah. I'm actually not sure it's not my wheelhouse either. I don't know if FTC requires it in the United States, but so much of the internet is global. So for largely why a lot of US companies will use the European standards for data privacy as, I just follow
As the
those
default.
because of the most stringent, so that if you're
Right.
good there, you're good pretty much everywhere else. That might be why I'm seeing it on the state side. 'Cause I'm seeing a lot of disclosures, but I don't know to the extent they're actually required here.
Yeah.
I am
For
so
us, it is
sorry, but
mandatory. Yeah.
I'm going to need to shoot off. I don't know
It's
if
okay.
Michael and Thanos, you
Hi,
can
Sarah.
stay
We
on.
got
Thanks.
7 extra minutes, so I appreciate it. And this is a good time to wrap anyway. We're over time. So thank you both. This has been great. Very
Thank you.
stimulating conversation.
Thank you for having us.
Of course.
Been great.